Hello, class. Because of the nature of this week's discussion and how it's set up to be basically a simulated negotiation, um, I found that perhaps having a little video discussion with you regarding these would be more beneficial rather than trying to point out several different items that may not apply to each of your considerations. Based on my experience, many attorneys and many union negotiators take different tactics in addressing situations like this. And from the attorney side of it, a lot of attorneys, they dream of scenarios like the one that we are having to deal with. They're focused on winning at all costs and hoping that somehow, some way, they can become a legal hero through one case. And sometimes through their hubris and self-righteousness, they can cause more problems for themselves and their clients. So today I want to talk about some of the pitfalls that the attorneys who represent clients who feel they've been discriminated against would face in a scenario that we are addressing. One of the biggest hurdles for an attorney representing someone in a situation like ours is the cost of litigation, because organizations normally have deep pockets just because of the nature of being a corporation. A plaintiff's lawyer in a situation like this is going to have to be well funded. They're going to have to be able to do due diligence and investigate, because what would happen is the employer obviously is going to have information that the client's attorney does not know. As a result, that attorney is going to have to go through the discovery process. And that discovery process is going to cost money, because even though the corporation would provide a lot of information, a lot of that information is going to be time consuming to find. And that attorney still has other cases to deal with. That's why you don't see solo practitioners handling union negotiations by themselves, because it's such a complex issue. And dealing with an employment discrimination can even be more complex if it's just one person handling. And in fact, some states, virtually in every state, your employment discrimination lawyers do not offer free consultation. As a result, you have a plaintiff that has probably forked over maybe $500 to $1,000 just to sit down and speak with the attorney. So from that standpoint, the attorney has an interest in getting something out of the employer. So when that discovery process starts up, that attorney already knows you don't want this client to be upset. So he's going to have to do something to recoup what the client has already paid. Now, in cases like this, the defendant's risk of losing is really related only to not just bad public relations, but the plaintiff's attorney's fees as well. So that's another incentive for the plaintiff to engage in litigation. So for an attorney, you have the temptation to try to fight a case that may or may not have merit versus the need to be paid. And I cannot tell you how many times in my state that issue has gotten several attorneys in trouble, where they have this case where they think it's a gold mine, so they spend a lot of money thinking it's going to be recouped, and they lose the case, and then they have to either declare bankruptcy or they do something nefarious that risks their law license. And unfortunately, it's more common than you think, because some attorneys need the money more so than their clients. For attorneys representing employees, the litigation may also turn into an obsession for the plaintiff, where nothing else matters to that person other than being vindicated. That's where the attorney's ability to counsel someone is really going to come into play. The attorney has to be able to step outside the case step outside of their intentions and ideas and really hone in on what's the best interest for the client. If there's not a lot of strong evidence in favor of the plaintiff, well, then it may not make a lot of sense to proceed. And that's where we get a gambling effect when it comes to discovery. The discovery process is basically both sides giving each other information in order to discover what evidence is out there to defeat or support claims. And if an attorney has a client who is just gung-ho about litigation and that attorney knows there isn't a case, the attorney will have to step back and simply say there is no case here, and they'll have to find somebody else. So that brings up the idea of settlements. What do we do when we're trying to settle these cases? Some attorneys want to settle in order to avoid litigation, or it may be more expensive. But then some attorneys want to avoid settlement and forge ahead, even after considering all the difficulties that I mentioned. And that's a real gamble. In my experience as an attorney, I gambled and I took some cases to trial. I lost some and I won some. But in many states now, we have loser pay laws. Loser pay laws are related to litigation where the loser pays for all the opposing counsel's attorney's fees. As a result, you could have a plaintiff's lawyer who gambled and lost and could now be on the hook for hundreds of thousands to millions of dollars in litigation. That's another reason why you don't see a lot of solo practitioners taking these employment discrimination cases. Now, there are some ways that could really hamper a case. Let's take, for instance, in states where you have at-will employment. At-will employment basically states that an employee or an employer can terminate the employment relationship at any point for any reason, so long as those reasons don't violate public policy, like for race, color, religion, sex, national origin, disability, etc. And some states actually expand those areas of consideration. So terminations always almost seem unfair to the employee, and that's where a good attorney and a good HR person is going to have to be prepared for what could be either frivolous litigation or a client who is just gung-ho about litigation and there's really no basis to argue it. And when you look at these cases, like in our scenario, the majority of discrimination discharge cases are going to come down to a dispute over an employer's stated reasons for termination and whether those reasons are pretextual. And the U.S. Supreme Court has found that when a court rejects the defendant's, the employer's stated reasons, the court can then infer, or the trier of fact can infer, the ultimate fact of intentional discrimination. So basically, if the initial reason for firing someone doesn't pass the smell test, then the court and the trier of fact, a jury, can come back and say, well, based on all these facts, we believe you, in fact, improperly terminated this person based on a discriminatory reason. And that, and the problem there is that may not have been the case at all. That may not have been the reason. But now that you had an employer who couldn't prove its case, couldn't defend its litigation, you have a jury or a judge assuming facts based on the evidence. And often when we make assumptions, we do a lot of harm to not just others, but ourselves as well. And remember, when we're in civil court, the standard of proof is not beyond a reasonable doubt. It's not there's another standard that escapes my mind. It's not clear and convincing evidence, So the standard is not clear and convincing evidence, and it's not proof beyond a reasonable doubt. The standard is the greater weight of the evidence. So the greater weight of the evidence is simply 50% point 0.000000001. So we're talking just a minuscule amount of evidence could lead to a poor verdict or the proper verdict. So when we're taking the position of a plaintiff representing a person who's been discriminated against, there are a couple of considerations that they have to take into account. And based on my experience, they have to ask their client, what's their gut reason for why they believe they were terminated? The attorney has a responsibility of really giving their client a good cross-examination to find out really what's itching their client. Are they angry that they got terminated, or do they really feel that they were discriminated against? Ask that client, what's the history? Were there previous reprimands? Were there other people fired? What were the circumstances of the termination? So these are issues that a good lawyer in the first person hour scenario is going to have to consider in order to properly prepare a case for litigation. The second question is going to come down to evidence. What evidence does the attorney know of, or does the attorney believe exists, that reveals the stated reason was not the true reason? So we go from the client's subjective to belief to the objective facts that we can find out pre-discovery. Were there prior letters written between the employer and the employee? Were there prior things done? Are there people you can speak with who may not work for the corporation? Are there prior whistleblowers? In other words, is there anything to help me find objectively that the stated reason is not the reason? We then have to consider what evidence that we know of at that point suggests that the termination was in fact based on the employees being in a protected group. I went over the various protected groups such as religion, race, sex, national origin. Do we have anything that would let us believe that the employer doesn't like particular race, doesn't like particular sex, doesn't like a particular origin? So that's going to require some observation, some history of the company. And this is another reason why good investigators are going to have to find out more about the company. And in the internet age, you can put anything on the internet, but most likely it's not coming off. It's going to be there in one way or another. Therefore, anything about that corporation that's negative that could support your client's case might be on the internet. So that might be the first place you want to look. So you have to look at the subjective and then the objective. And then a final consideration might be, did the termination result from a reduction in force or layoffs, or did those layoffs disproportionately impact a protected group? Here, there may have been no intention to discriminate against a group, but when decisions were made, they did, in fact, in practice, have a discriminatory effect. So those would be the top questions that, as an attorney, you would need to ask, that you would need to ask your client. So as you think about some of the things that you want to consider, this would be the first scope that you would need to cross. What information can you find before you even send your demand letter?